good morning, good evening, depending on where you're from. My name is Bayo Akilade, and I am going to be the anchor for today. My lords, justices, judges, my learned friends from different places in Africa and around the world, I welcome you. In the next 10 minutes, we shall proceed. With no particular order, I just want to welcome my Lord Justice Nene Amagacha. Wonderful to have you here. It's been ages. And everybody that is here, Professor Andrew, it's good to have you here. It's good to have all of you here, and we will start shortly. And our host will also be with us. She's already online, but she's getting ready, and we will be with you all shortly. Thank you. Good afternoon, everyone. It is a pleasure having you all here in this Zoom meeting. Special thanks to our speakers who have made time out to share knowledge with us and be available to us to share their experiences and to help us navigate through the justice system. Good afternoon once again, and my name is Bayo Akinlade. I am a Nigerian-born legal practitioner, and I am going to be your anchor for today. And we hope that this session will be one that will not just be something we can have a discussion here, but something that we can take out of the Zoom environment and practice what we've all learned in this place. So I will go immediately to introducing our host and the convener of the session for today, and somebody who has had a passion for the judiciary as a whole, Dr. Ari Nikitobi. She is the founder, CEO of AT Socio-Judicial Consulting, a judicial consulting firm that is focused on advancing judicial jurisprudence and rebuilding public confidence in courts through socio-judicial research. Ari obtained her LLB and LLM from Nigeria and MJS and PhD from the United States of America. Ari is a former magistrate of Lagos State Judiciary in Nigeria, where she served on the bench for over 12 years. Her goal is socio-judicial research, which I personally think is a wonderful area, which it's not very common in the normal parlance of the legal profession. In her quest for socio-judicial research and development, 2 decades of research on courts and society, Ari propounded her socio-judicialism theory on socio-judicial theory of justice and initiated this unique courts and society webinar series, which gathers judges, intellectuals, students, and the public from various countries to build intellectual relationships and discuss socio-judicial concerns and judicial development. Through CSWS community platforms, Ari served diverse groups' needs in her community, a criminal justice platform that focuses on community policing, a children's platform, and a platform that celebrates women judges from various countries. Ari's passion for social justice and in advancing judicial jurisprudence is evident in diverse peer-reviewed publications and presentations at several national and international conferences. Ari is also a reviewer of the International Journal of Law and Society and has held chair and discussant roles in several international conferences. Ari is committed to social justice and community development. She is an active member of the several boards in our home community in the United States. Ari is a 2-time PEO International Peace Scholarship Award recipient. She received the University of Nevada Graduate Dean's Merit Scholar Award, the United States Senator Catherine Cortez Masto Certificate of Commendation, the National Judicial College Certificate for Judicial Development, the G100 Law and Justice Empowerment for Women Certificate of Recognition, and the Borough of Queens, City of New York Citation of Honor. She is the first Nigerian African woman to earn a master's degree in judicial studies. Also, the Journal for Blacks and the University of Nevada, Reno, recognized her as the first Black woman to obtain a PhD in judicial studies in the United States. Who better than to come up with a topic and a theme that talks about the public perception of the justice system. May I introduce to you Ms. Ari Nikki Toby. Thank you, Ari. You have the floor.
Thank you so much, Bayo. Good morning, good afternoon, good evening, depending on your different time zones. The Honorable Chief Justice of Uganda, Honorable Justice Alphonse Owindolo, represented in absentia, represented by Professor Andrew Kauka. I don't think there are any other Chief Justices here, but Supreme Court justices of different countries here present, justices of the Court of Appeal from different countries, High Court judges, senior advocates of Nigeria, magistrates, senior advocates of Nigeria, professors, distinguished professors from different universities and different fields, ladies and gentlemen, definitely my distinguished honorable speakers. A brief introduction about this Court and Society webinar series. I would share my screen. The Court and Society webinar series, the first of its kind actually, doing a research on this for so many years, over 21 years of research on courts and society, started after the Honorable Justice Nikki Toby first biennial symposium in 2021 in Abuja, Nigeria. It was an in-person event that was titled The Nigerian Judge and Society, Justice Nikki Toby's Impact on the Development of Law and Society. This free webinar series honored the late Honorable Justice Nikki Toby, a distinguished Nigerian judge whose integrity stood out. And if you want to know more about him, you can search our interim webpage and you would see a little about what he stood for. So accordingly, in his honor, we decided to come up with this regular annual event. Sometimes, depending on the availability of our speakers, we organize it every 3 months, quarterly, or 4 months. And today, this 8th webinar edition, we'll be celebrating the judicial jurisprudence of Uganda, Ghana, Kenya, Nigeria, and Malawi. The goal basically is to reach out to as many people out there who do not understand the modus operandi of the court system, who would always judge judges not knowing what judges face and go through, especially the dilemmas judges face, and to help to get a synchronized relationship in the justice system, to connect international relationships, as it were, and many other issues, especially on cultural issues as well, to celebrate judicial cultures from all over the world. We've had 7 webinars so far, and we've had different distinguished speakers, from justices of the Supreme Court to justices of Courts of Appeal, to former presidential aspirant, to Chief Justice of a country, and different distinguished professors, and so far, with different topics that bother on judicial development and the well-being of a judge. The late Honorable Justice Nikki Toby, in his book, The Nigerian Judges, says, so much is expected from a trial judge because so much power is vested in him by the law. He is therefore expected to perform his judicial functions clearly to the glare of the public and for the consumption of the public. He should on no account allow the public to doubt his personal integrity and fidelity of purpose in whatever he does within and outside the court, as his life relates to his judicial function. He went on to say that the duty of a judge is to hold the balance between 2 competing parties. He is called upon to discharge a very difficult, delicate, and at times fragile duty. He can hardly be heard to defend himself in public if he is censored or criticized for his judicial actions or inactions. And lastly, the late sage says that the public actions of a judge and the utterances of a judge are watched by the entire populace, and not only by the litigants who are his immediate clientele, so to say. As a judge, his actions or inactions are on trial. While by the very nature of his humanity, he is a human being, the public look at him as a superhuman being who cannot and should not commit any rage. And so, knowing the lives of the judge and the challenges that judges face today, and as we've been doing for the past 7 editions, as we hope to do, God giving us life and health, to cut across as many countries as we can to celebrate judicial jurisprudence and judges. Today, we celebrate the judges of Uganda. We celebrate Nigerian judges. We celebrate Kenyan judges. We celebrate Ghanaian judges. We celebrate Malawian judges. And we ask that the Lord would give them strength to continue to judge in righteousness and justice. Usually, when we have a Chief Justice of a country, it's our tradition to honor the national anthem as a #1 judicial citizen of a nation. However, because we cannot stand, since it's a virtual event, so we would not be singing the national anthem, so we do not disrespect the flag of the Republic of Uganda. So even though I tried to ask as many protocol officers as I could in the executive and legislative arms and judicial arms, no one was able to give me a way out. So I decided to come up with this, where I would just recite it while we are sitting down in honor of the Chief Justice of that country. O Uganda, land of beauty, the national anthem of the Republic of Uganda. O Uganda, may God uphold thee. We lay our future in thy hand. United, free for liberty. Together we'll always stand. O Uganda, the land of freedom. Our love and labor we give. And with neighbors, all at our country's core, in peace and friendship we'll live. O Uganda, the land that feeds us, by sun and fertile soil grown. For our own dear land, we shall always stand, the pearl of Africa's crown. Our keynote speaker, the Honorable Chief Justice Alphonse Siga Moy Owindolo, in absentia represented by the Professor Andrew Uka. I hope I don't mess up your name, sir. He was the Deputy Chief Justice, the head of the Court of Appeal, and the head of the Ugandan Constitutional Court before his appointment as Chief Justice of Uganda in 2020. His lordship was a judge of the International Crimes Division of the High Court of Uganda, where he delivered the famous judgment on the 2010 Kampala terrorism bombing case. The Honorable CJU has served critically in all 3 arms of government as Minister of State in charge of the Northern Uganda Reconstruction Program, NURP, as a member of parliament and as a delegate to the historic Constituent Assembly that framed the Ugandan Constitution of 1995. As a practicing lawyer, his lordship was involved in the peace talks between the government of Uganda and the then rebel group, Uganda People's Democratic Movement, UPDM. The Honorable Chief Justice met with Joseph Kony, the notorious warlord, for peace talks. Hence, he wrote the historic peace agreement between the government and UPDM. The Honorable CJU earned a Bachelor of Law degree from Makerere University, a diploma in legal practice from the Law Development Center of Kampala, and a Master's of Arts in Conflict Resolution from the University of Bradford in the UK. Also, the Center for Conflict Resolution, South Africa, awarded the Honorable Chief Justice a certificate in advanced conflict mediation skills. I'm having a call right now from Professor Andrew Kauka, the representative of the Chief Justice. It's one of the issues that come up when you have very important personalities. We have to adhere to such protocols. The Chief Justice apologizes for his inability to be here. Professor Kauka has just called and said that they're having network issues and they're trying to fix it. So he would come on as soon as he can. So while we're waiting for him, I would go on and read our next. Can we all see the screen, please?
Yes.
So the next speaker and discussant for this distinguished panel, Honorable Justice Joyce Aloch. The retired Honorable Lady Justice Joyce Aloch was a judge and first vice president of the International Criminal Court at The Hague in the Netherlands. Her judicial career began at the Magistrate Court in Kenya, where she ascended to the High Court and then to the Court of Appeal before her election to the ICC. My lady was recently appointed a member of the Judicial Reform Committee under the revitalized agreement for the resolution of the conflict in the Republic of South Sudan. As a certified mediator, she conducts international mediations and court-annexed mediations in Kenya. She serves in many international and regional organizations, including the International Advisory Board, Office of the Ombudsman of the United Nations Funds and Programs. Justice Alouch is also an adjunct professor at the University of Western Cape, South Africa. She was appointed chair of the Nairobi Peace Congress 2023, organized by Mediators Beyond Borders International. Milady was appointed a member of the jury of Simple Semente donor and recently was appointed the Global Advisory Council of G100 Global Networking. Milady is a recipient of several international and national awards, including Kenya's Presidential Awards, CBS, EBS, and the Trailblazer Awards from 3 different presidents of Kenya. She also recently received the International Peace Award from, and I actually spent time on the internet this morning trying to pronounce this word with an Italian tongue. Premio Internazionale Semplicemente Donné in Florence, Italy. The next, Honorable Justice Nene Amegate, was appointed as a Justice of the Supreme Court of Ghana in October 2018 and retired in August 2023. He was called to the Ghana Bar in 1980 and practiced law actively. He became a managing partner of Sam Okut Zeto, an associates law firm. He also served as an adjunct lecturer in ADR, advocacy, and legal ethics at the Ghana School of Law, Accra. Justice Amegate is a past president of the Ghana Bar Association. He has also chaired the African Regional Forum of the International Bar Association, the chair of the African Region of the Commonwealth Law Association, and chair of the Advisory Council of the College of Humanities at the University of Ghana, Legon. Justice Amegate once represented Ghana at the International Chamber of Commerce, ICC, Court of Arbitration in Paris. He has also been a member of the Judicial Council and General Legal Council involved in issues of judicial integrity, judicial ethics, and development. His lordship holds a Master of Law degree in Advanced Litigation and Dispute Resolution from Nottingham Trent Law School, UK. The next speaker, Mr. Yemi Kandi Johnson, SAN, is a senior advocate of Nigeria and a senior partner at Stratton Partners Law firm with domestic and international practices of commercial arbitrations, maritime, petroleum, banking, and construction industry matters. He is also an advisor to foreign investors on regarding potential investments in Nigeria. Mr. Kandi Johnson, SAN, is a former president of the Lagos Court of Arbitration, which is Africa's foremost dispute resolution institution, and the chairperson of the board of directors of Nigeria Mortgage Refinance Company. The Learned Silk, as popularly called in Nigeria, SANs are called that, is the coordinator of the Justice Reform Project focused on formulating and advocating ideas of judicial reforms in Nigeria. He headed the Lagos State Judiciary Backlog Elimination Program, which analyzed and rewrote protocols for civil litigation in the High Court of Lagos State. A chip of the whole block, as I would call him, though from the bar, he is devoted to building upon the legacy, and of course, his own legacy as well, of his late father, a former Chief Justice of Lagos State. Senior Advocate Kandi Johnson has authored several scholarly papers and co-authored a book, Commercial Arbitration Law and International Practice in Nigeria, a significant contribution to arbitration practice in Nigeria and West Africa. He was conferred with the rank of Senior Advocate of Nigeria in September 2003. He's a fellow of the Chartered Institute of Arbitrators of England and an honorary fellow at the Center of International Legal Studies in Salzburg, Austria. The last but not the least speaker, Ms. Janet Zinat Karim, is an author, editor, journalist, columnist, special education instructor, advocate, and a former diplomat. She is Malawi's renowned media professional with an illustrious publishing career spanning over 40 years in print, broadcast, and social media. As a journalist, Ms. Karim has contributed to dialogues that helped shape Malawi's modern Malawi. She founded a newspaper, The Independent, which called for domestic change in Malawi. She was also a radio broadcaster who created a children's radio show, Slap Me 5, God is Alive series. In civil society work, Ms. Karim co-founded the Malawi Media Women's Association, which established Malawi's first community radio station, CSWS Community Radio, supported by funds from UNESCO. She participated and advocated for the inclusion of pro-women, pro-children, and pro-youth Bill of Rights. As a diplomat, she championed, together with all of her other colleagues, the voice of Africa, facilitating the call to end child marriage. Thus, Malawi became one of the first countries to pass legislation against child marriage, early and forced marriage of male and female children. Ms. Karim has authored 3 books which are on Amazon and several literacy work, which include fictions and non-fiction genre. She's a columnist in The Nation under the column title, These Freedoms, and 3 online news media, Maravi Post, African Global Village, and Malawi Diaspora Network, through which she contributes her weekly My Take on It column. She has an MA in Sociology, Global Development, and Social Justice from St. John's University, New York. Ladies and gentlemen, since we do not have, okay, we have him on now. We have the professor on now, Professor Andrew.
Yes, I am on. Yes, I am on. Sorry.
Yes, sir.
I
introduce you
had
briefly?
now to use the. Kindly do.
Thank you. Professor Andrew Kauka, who is representing the Honorable Chief Justice, who sends his apologies today, and our prayers and condolence go with the country of Uganda, where they're having presently, in honor of a late prosecutor of the nation that was murdered. So the president and all of Uganda's executive, legislature, and judiciary are all there gathered presently. So the Chief Justice sends his apologies, and we send him our condolence, and our hearts and prayers are with Uganda. Thank you, sir. Professor Andrew Kauka is the technical advisor of the judiciary of Uganda from 2015 to date, and also adjunct professor at Pepperdine University School of Law, Malibu, California. As technical advisor to the judiciary, he is responsible for advising the Chief Justice and the leadership of the judiciary of Uganda in innovations and judicial reform. He was the lead researcher and secretary of the committee that developed sentencing guidelines for Uganda and the rollout of plea bargaining, and is also currently advising the judiciary on engineering alternative dispute resolutions in Uganda. Professor Kauka coordinated the first African Chief Justices Summit that was held in Kampala, Uganda, from the 5th to the 6th of March 2024, and also the first high-level National ADL Summit in Uganda, and was held from 26th to 27th June 2023. Currently, he's undertaking a PhD research sorry, I just got all of this, so it's taking me a while to get it. Currently, he's undertaking a PhD research. And specifically, I'd like to say about that the Chief Justice had sent somebody who indeed is a man of integrity as a dean of a law school said, and I quote, "I know him to be a man of the highest character, highest integrity, and a man who embodies servant leadership. I cannot think of a man more deserving of joining the faculty of Pepperdine Law School," as Professor Kauka. So thank you, sir, and we thank the Honorable Chief Justice for sending a representative that is worthy, that speaks to the topic from his life and his character. Professor Kauka, thank you, sir. Professor, has the network gone again? It's part of what we face in that part of the world. Even here, as a matter of fact, early this morning, I had a network glitch here in New York. So it's good morning. Now that I'm less stressed and a bit, because I got to know about the Chief Justice very late, so I was a bit disorganized this morning. And so I say good morning to all of you wonderful speakers. Good morning, Lady Justice. Good morning, Benedict Sayen. Good morning. Good morning, sir. Good morning. Okay, he's back. He's back. So, Professor Andrew, thank you, sir.
Can you hear me now?
Yes, sir, we
Yeah.
can hear you. Thank you. And thank you for
Can
all
you
the
hear
trouble
me?
you've been through
Yes.
to be here. We can hear you, sir.
Sorry for what happened. I bring apologies from the chief to be with us. I will read his keynote address word by word. But perhaps before I begin, kindly allow me to Your Lordships, retired justices, distinguished ladies and gentlemen, kindly allow me to adopt that protocol. This is a keynote address that I am reading on behalf of the Honorable the Chief Justice of Uganda, the Honorable Chigamoi Dolo. I felt honored when I received the invite to be the keynote speaker at the 8th edition of the Courts and Society webinar series under the theme, The Impact of Public Opinion on Judicial Integrity and Democratic Development. Before I venture any further, I would like to appreciate AT Socio-Judicial Consulting for taking deliberate efforts towards enlightening judges, the media, stakeholders of the criminal justice system, and the general public about the real and ideal roles of courts in society through various ways, including this webinar series. This helps to bridge the gap between the law and society and to reduce public confidence in our justice system. This is a noble cause, and I applaud ATSJC. To all who are participating and our tuned in online series, I thank you. The topic at hand is an interesting topic that I personally have mulled for years and have had experiences relating with. I am thus glad that you have given me a platform on which I can not only learn, but also share my personal experiences and views with you. Judicial integrity. A democratic society should have a system of accountability where holders of public office, such as legislators, electoral officials, and political leaders. Judicial power is the authority given to the courts to declare and interpret the law, and as such, ensure that they are of fundamental human rights, faithful to the goals of democracy by some and the executive, and must also act as an arbiter between litigation. Judicial integrity is key. This refers to the ethical and moral principles that guide the behavior and decision-making of judges, ensuring that they act with impartiality, fairness, and honesty in the discharge of the judicial duties. And these include independence, impartiality, accountability, and person, as well as absence of corruption or influence, respect for the law and the judiciary, no use of power for personal or political gain, and self-improvement, in public trust and confidence in the judiciary, and ensuring that the legal system holding the rule of law. Public opinion. Public opinion refers to the collective attitudes, beliefs, and sentiments of a population on various issues, events, policies, or individuals. It represents the aggregate views of a community or society on matters of public concern. It is shaped by a multitude of factors, including but not limited to personal experiences, cultural experiences, socio-economic backgrounds, media coverage, and interpersonal communication. The key characteristics of public opinion, therefore, include diversity, reflecting the different perspectives, values, and interests within a society, covering a range of viewpoints, from those held by the majority to minority opinions. Public opinion is also dynamic in nature, in the sense that opinions can change over time in response to new information, events, or shifts in societal norms. And ability to influence decision at various levels of government and other institutions. The role of the media to influence the opinion leaders in shaping public opinion through selecting which issues to cover, framing new stories, and influencing the narrative surrounding the events and policies cannot be overstated. On this note, the press are always blamed for disappointing depth, frequency, and fairness of its coverage of the court. Intermittent coverage of the court from the most newspaper stories that rarely give context, explanation, impact, or reaction by affected groups or individuals, covering only a tiny fraction of the court's decision, primarily those concerning freedoms of press issues, providing misleading and damaging focus when the court is covered, overemphasizing the political appointment process to imply that the justices are merely representing a particular legal standpoint, and oversimplification. And yet, their endorsements on statements can sway public attitudes and behaviors. In some instances, personal attacks are made against judicial officers about the way they execute their mandate. Caution thus should always be heard by all, that while public opinion is influential, it is also subject to manipulation, subject to misinformation and biases, highlighting the importance of critical thinking and informed citizenship in interpreting and shaping public discourse, and for those in government, or in the case of the judiciary, in responding to it. Public opinion is operated under the United Nations Declaration of Human Rights, the ICPR, the African Charter by several constitutions of different countries. Article 19 of the UDHR provides, everyone has the right to freedom of opinion and expression. This right includes freedom to hold opinion without interference and to seek, receive, and impart information and ideas through any media and regardless of frontiers. Article 18 provides that freedom of thought, conscience, and religion. It further provides that the rights include freedom of change, belief, and freedom, either alone or in community with others, and in public or private to manifest their beliefs. Article 9 of the Charter on Human and People's Rights and the Declaration of the Principles of Freedom of Expression in Africa, all at least to be protected from the status of freedom. The Supreme Court of Zimbabwe, in Mark Gova, Chavundaka, and another, versus the Minister of Home Affairs and another, enumerated the objectives of the freedom of expression. I quote from the decision of the court: freedom of expression has 4 broad special objectives to serve. 1, it helps an individual to obtain self-fulfillment. 2, it assists in the discovery of truth and in promoting political and social participation. 3, it strengthens the capacity of an individual. 4, it provides a mechanism by which it would be possible to establish a reasonable balance between stability and change. This freedom is not non-derogable. However, in cases where such a freedom is to be limited, the limitation should be one justified in a free and fair democracy. For the case of Uganda, we have a matter that the Constitutional Court deliberated on, and this is in the case of Charles Onyango Bo versus Attorney General. The Supreme Court of Uganda stated thus: limitation is imposed by Article 43 of the Constitution of the Republic of Uganda on freedom was not an end in itself, and it had to be considered in light of what is acceptable in a free and democratic society. Such is the light through which public opinion should be viewed. I emphasize, these are the words of the Honorable the Chief Justice, I emphasize here that public opinion, positive or negative, is a protected freedom. The Uganda Supreme Court has rejected the notion that extending the constitutional protection of freedom of expression to false statements is incompatible with upholding truth. It held rather that a scrutiny of the limitation under Article 43 of the enjoyment of rights did not end any credence to the supposition that the protection does not extend to false expressions. This applies especially to misinformed public opinions. The Justice of the Supreme Court, as he then was, Justice Mulenga, stated that extending protection of the freedom of expression to false statements does not necessarily defeat the objective of upholding the truth, because while truth and falsity are mutually exclusive, the purpose for protecting both are not. It is not confined to categories such as correct opinions, sound ideas, or truthful information. Subject to the limitation is under Article 43, a person's expression or statement is not precluded from the constitutional protection simply because it is thought by another or others to be false, erroneous, controversial, or unpleasant. Everyone is free to express his or her views. Indeed, the protection is most relevant and required when a person's views are opposed or objected to by society or any part thereof as false or wrong. My remarks, therefore, approach the impact of public opinion on the basis that the presence of such respect according to public opinion, especially negative opinion, is indicative of the progress in a democratic society. Its impact on judicial integrity is to be assessed in regards to encouraging the media to have improved quality of reporting on the judiciary. How the judiciary can better package and improve its business to serve the country, officers with positive skills of dealing with this negative impact in their lives and work. How does public opinion, ladies and gentlemen, affect judicial integrity and democratic development? The judiciary and courts occupy an ambivalent position in relation to public and its attitudes. As a branch of government, the judiciary is subject to criticism, commentary, and opinion expressed in the public spheres across different media. It is interesting to know how it impacts on the opinion of judges, especially as, unlike the legislature and members in the executive arm, judicial officers have limited capacity to respond to or influence public opinion. This is in part due to the nature of the judicial role. The separation of powers allocates constitutional responsibilities to the executive and the legislature to engage politically with the electorate, which contrasts with the judicial role to decide cases brought before the court by parties, and to do so impartially and dispassionately by applying the law to the relation to public attitudes, and the media can result in tension for individual judicial officers and challenges for courts as institutions. Understanding judicial perceptions of these complexities may provide a basis for effectively addressing the challenges, especially because the judiciary, individually, collectively, and institutionally through the courts, bears the primary responsibility for communicating with the public about its work. Public opinion can significantly influence judicial integrity and democratic development in several ways. Legitimacy of the judiciary. Public perception of the judiciary's fairness, impartiality, and adherence of the rule of law is crucial for its legitimacy. If the public perceives the judiciary as biased or corrupt, it undermines trust in the entire legal system, leading to a loss of legitimacy. Conversely, public opinion enables the credibility and the authority of the judiciary. Accountability. Public scrutiny encourages judges to act responsibly and ethically. Judicial misconduct, and ensure that judges adhere to their ethical obligations. Public opinion serves as a check on the judiciary's power, holding judges accountable for their actions. Policy influence. Public opinion can influence judicial decisions indirectly by shaping public policies. Judges may take into account prevailing public sentiments when interpreting laws or making rulings, particularly in politically sensitive cases. This can sometimes lead to decisions that align with public opinion, although judges are expected to prioritize legal principles over popular sentiments. This has been apparent in the sentencing process, for instance. Democratic values. A robust public discourse about judicial issues fosters a deeper understanding of democratic principles, such as the separation of powers, the rule of law, and the protection of individual rights. Public engagements with judicial matters promotes civic education and strengthens democratic norms. Reforms and institutional changes. Public dissatisfaction with the judiciary can catalyze calls for reforms and institutional changes aimed at enhancing transparency, accountability, and efficiency within the judicial system. Public pressure can compel policymakers to enact legislative reforms or establish oversight mechanisms to address perceived shortcomings in the judiciary. How should the judiciary respond to public opinion? Challenges of public opinion to judicial integrity. Many times, the criticism of the judiciary by the press has been that the courts are snobbish, fearful, cloistered, and deliberately uncooperative with the press, failing to provide visible news stories on a continual basis, not providing personal contact with the justices for press interviews to help to clarify on their judgments, not institutionally assisting the press by providing timely information to fit with the news circles and video coverage, or same-day transcripts of oral arguments. Before assessing or addressing possible solutions, it is admitted that some tension is inevitable and that the interests of the court will never be fully served by the media and vice versa. Both the nature of the medium and the audience the press addresses prevent the press from becoming ideal articulators of detailed legal analysis, but rather tolerance and understanding, alongside various practical measures, could move both sides in a more democracy-serving direction. The press could become better versed in legal terminology and reasoning by employing legal specialists to improve legal literacy. Moreover, by committing to avoid bench bashing and distortions of the judicial role for the sake of rating, relations would be significantly improved, and the process would strike a better balance between educating the public and entertaining them, a balance that has significant implications for reportage of the judiciary in particular. I find it pertinent to address the issue of influence of public opinion on the judicial officer and the judiciary at large as well. Since I find these to be intertwined issues, it is indisputable that public opinion can spur positive change when voiced and acted upon by those responsible. However, in this case, it can also negatively impact individual officers and the judiciary. Public opinion's influence on the judicial officer and the judiciary. There is a sense that public comment on judicial work, however critical or ill-informed, is inevitable. And we have to realize that criticism goes with the territory. The perceived criticism can affect individual judicial officers on a personal level. For some, they find that the media emphasizes unfairness, negativity, or criticism in the sense that it is frustrating, grieves me, or gets me down. Others identify that the frequency was an aspect of the problem, that such criticism is consistently negative or occurs so often. In a research conducted in Australia, the negative effects of criticism were described as reducing the satisfaction and loss of respect or status. The geographical location of some courts may also affect the media coverage. A newspaper may routinely publish a photo of a face of a magistrate when reporting a case. It is also likely that individual judicial officers experience criticism in different ways, perhaps reflecting previous experiences with public or media engagement, either positive or negative. The demands pressed on journalists by the 24-hour news media was also raised, with the argument that it trivialized much reportage with an undue focus on irrelevant, minute, and personal details, such as a judge's sexuality. Ordinarily, a judicial officer is expected to handle every matter that comes before him or her impartially on the law and facts, independent of the public opinion. They are expected to raise above the criticism and carry the weight. This is better expressed by Matthew Baker when he was reporting on a discussion that was made by Sir Mark, a former president of the influenced the judiciary, a judge's perspective. Sir Mark Porter's argument was underpinned with the belief that the decisions of judges are not, on the whole, influenced by the views of the media commentators. Nor are they motivated by any concern as to how their decisions may be reported once delivered. He considered that judges engage with the media in a similar way to all of us, and as such, in a broader sense, they are open to the influence of the media like everyone else. But asserted that historically, judges' backs have been broad and they remain so. He was clear that their task is to apply the law to the facts, and that they have an obligation to put both personal opinion and the media comment aside, since the latter is often misinformed as to the full details of the case at hand. To formulate his argument, and that applied in the civil courts, and between the substantive law applied in individual cases, and more widely, the rules of court procedures and practice directions, and the hearing of cases in open court. On the first point concerning criminal law, he reaffirmed that no magistrate or judge does other than decide each individual case by reference to the law. But that interestingly, jury praising to some observers, not the least the judge, following intense media coverage of a particular case. On sentencing, Sir Mark was distinctly more open to the possibility of media influence. Indeed, arguing that since judges have been appointed by society as the person is responsible for punishing criminals, in deciding what punishment to deliver, they should have regard to public opinion without necessarily following it. In these situations, judges are reliant on the responsible media to actually reflect public opinion, considering this alongside the statistics and figures pertinent to the case. Turning to civil decisions, I draw our focus to cases raising interesting or undecided points of law that gain media attention as they proceed on appeal. These tend to involve difficult questions of human rights, such as those involving suspected terrorists or murderers. During drawing on personal experience, media comment is ignored in deciding these cases. But where key parts of the judgment are vulnerable to being misunderstood by the media, it is helpful if these are clearly spelled out. I myself, this is now the Honorable Chief Justice, did this in my recusal ruling during the last presidential election petition in Uganda in 2021, and even pointed out what considerations a judicial official should take into account in deciding, making when faced with criticism from the public. The applicant sought my recusal on the basis that since I represented the candidate as a personal lawyer in 2006, this is now the Chief Justice saying he represented the president of the country as a personal lawyer in 2006. And this is why one of the parties was seeking that the Chief Justice should recuse. And the Chief Justice is saying, I could not 8 years later hear a matter impartially or without perceived bias. Declining to recuse myself and ignoring certain popular sentiments, I delved into the law of bias and explained in detail why I would not recuse myself. For the benefit of the public opinion, I'll read an extract of it. This is now the extract that the CJ has in his address that I'm reading to you now. I quote, with regard to the public, which the applicant is concerned with, I need to point out that it is actually comprised of three broad categories of persons. The first category comprises those driven by ill motive or ulterior motive. They actually know the truth about the matter in issue, but because it serves their malicious enterprise to present a position converse to the true position, they hype that which best ensures the realization of that purpose. They are ordinarily in the minority of society, but because they may be cunning or are a little more informed than the ordinary persons and are quite noisy, they create the impression that the silent majority is with them, or that the views they express present those of the majority, whereas not. By no account are they objective or reasonable in what they perpetrate and perpetuate. Accordingly, their views cannot be the measure for the test of bias. The court continues. The second category of the members of the public, which usually constitutes the majority in any society, comprise the ordinary persons who are generally well-intentioned manipulation. They can easily jump on any bandwagon, including that driven by the first category of persons acting in pursuit of ulterior motive. When they are negatively bold, they can be quite unreasonable and dangerously subjective. They are only useful with regard to the test for bias when their minds are positively directed. And the third category of person is comprised of the objective, fair-minded, and reasonable persons. However, these qualities alone are insufficient for them to pass the test for bias. Judicial officials should keep these categories of people in mind before responding. Some criticisms are to be ignored. Some misinformation explained away, and reason is always given in every decision in a way that exhibits integrity. When it comes to appellate judgments, four main influences on the judge's decision-making process have been identified. These are quality of the judgments in the courts below, counsel's arguments, interaction and discussions with their colleagues about the case, and legal academic opinion. An example of this is the amicus brief that helps various interest groups filter their views into the court's decision. Even in the appellate courts, whilst we acknowledge that today's judicial officers may lead less insulated lives than their predecessors, there should still be a certain level of imperviousness to media influence. Engagement with the public opinion not ignored, so that someone has to respond to the public. Originally, the Attorney General has the mandate as part of government. However, this does not in general, since this may be more efficient. And as already stated, the judiciary has the mandate to educate the public on its role. This is an ethical obligation based on open justice or transparency and accountability to the people. However, any move to respond must confront the ambiguous and limited judicial role in direct public communication outside court. Generally, judicial engagements with the public is complicated by the realization that while some audiences can be addressed directly, most people engage with the courts only indirectly via media reports. People may have direct experience with the courts as a litigant, criminal defendant, witness, juror, assessor, or attending court as a member of the public. However, research finds that very few people may have any first-hand experience of their courts, though when they have such experience, it can only highly be influential on their views of the judiciary. Other sources of information may include personal contact with someone else with the experience of the courts, such as a friend or family, or information provided by courts themselves, such as through case decisions or sentencing remarks, published online or in print, judgment summaries, social media communications or presentations to schools or community groups. For most, the major sources of information are from media, including newspapers, television, radio, internet sites, and social media. These can play valid roles in the relationship between the courts and the judiciary and the public. By urging all judiciaries, civil society, and the government to remain mandate or promotion of human rights. Today's webinar series, Socio-Judicial Consulting, not to tear or compromise on your commitment to promoting democratic development. I thank you all for your kind attention. Chief Justice of Uganda, Alphonse Chigamoy Owinyi Dolo. Ladies and gentlemen, I simply read what had been delegated to me by the Honorable the Chief Justice, word by word. I could not summarize it because it was not my keynote. That's why I had to read word by word. Thank you very much for your kind attention.
Thank you so much, Professor. Thank you. That's why I was careful not to stop you. Thank you so much. We appreciate it.
I submit.
Extend our regards to the Honorable Chief Justice. We hope to have him sometime in person again. Thank you, sir, and all the best. We'll go straight up to our next presenter, please. Because of time, we'll call on Honorable Justice Joyce Alouch, please. Your presentation, ma'am. Thank you.
Thank you for giving me the opportunity to make my very few remarks. And may I first observe protocol. The Honorable the Chief Justice, very ably represented by Professor Kauka Andrew. All distinguished participants, ladies and gentlemen. It's now just in Kenya, in Nairobi, Kenya, where I am right now, is 4:32 p.m. in the afternoon. I'll go straight away into my remarks. I hope they are brief. Now, let me start by saying that integrity, independence, and impartiality, these are key requisites for establishing an effective and functional judiciary and judicial system for peaceful resolution of legal disputes and democratic development. I think the Honorable, the Chief Justice very ably defined integrity, but I'll just add something onto it and say that according to me, integrity is a holistic concept that refers to the ability of the judicial system or a member of the judiciary to resist corruption whilst fully respecting the core values of independence, impartiality, personal integrity, propriety, equality, competence, and diligence. These values are identified in the Bangalore Principles of Judicial Conduct endorsed by the United Nations Economic and Social Council in its Resolution 2006/23. Judiciary is an independent custodian of justice, just as the Chief Justice said in a few minutes ago. Now, if I begin from home where I am right now in Kenya, let me say that the primary role of the judiciary of Kenya is to exercise judicial authority given to it by the people of Kenya. It is also mandated to deliver justice in line with the Constitution and other laws. The Kenyan Judicial Code of Conduct provides, and permit me to quote, in all activities, a judicial officer shall exhibit respect for the rule of law, comply with the law, avoid impropriety and the appearance of impropriety, and act in a manner that promotes public confidence in the integrity and the impartiality of the judicial service. Permit me to quote a judge from the Netherlands. I lived in the Netherlands for 9 years. That's where the ICC is. This was Judge Max Parks, was a senior judge and a press judge for a particular county. Now, he said, we need to reflect on how a judge's integrity is evidence and how it can be seen to be believed by the public. But he also charged the public to be responsible as they comment about the judges. And the public was so, again, very ably, we were told very ably by the professor what the public means. I simply say that popular opinion, views prevalent amongst the public, or the collective opinion on a specific topic. Judges are aware of the importance of ensuring that court sessions are open to the public and that no obstacles are put on the way of journalists who want to report cases. But at the same time, journalists are also called upon to report fairly and honestly when they are in court. But these are open. Most courts are open. Most cases are heard in public unless for good reason to be reported, to be noted down by the judge why a matter must be heard we had not in open court. These are all part of modern interpretation of the rule of law, which or modern interpretation of the rule of law, which was expressed by an English author, J.B. Morton, and when he said, and I quote him, "we believed," unquote. This same principle also applies to judicial integrity. And the question is, should integrity not also be seen to be believed? As one who has served as a judge for 44 years, by the time I retired from the public to be fair in their comments about judges, to be honest and fair to the judges. A judge must decide the case on the basis of the facts on record, the law. If it is both male or female, as often quoted, a judge like CSWS.
I think because of the network issue, she's probably had the network glitch as well.
Can you hear me now?
Okay, you're back. Thank you.
So, I don't know what happened. I'm sorry. It is a lot of rain outside. Sorry. Permit me to quote the words of a former Slovak Constitutional Court president who once said, "No judge lives in isolation. Therefore, I am conscious of public opinion polls, various petitions, newspaper articles, discussions, proclamations, politicians and lawyers, and public assemblies. Judges in democracies cannot win public trust by seeking publicity and following public moods. They can win trust. As judges, we can win trust by deciding according to the law without regard to the public opinion." This quote shows the position of judges around the world. It shows that judges live ordinary lives just like other people do. However, when deciding cases, they should forget about the outside world and strictly follow the law. As a former judge, I believe that a judge should be honest, honorable, reliable, and incorruptible. I endeavored to display all these qualities in my long judicial career spanning over 44 years, and I enjoyed it without ever looking behind me to see who was watching what I was doing. So many times I got comments like, "In Justice Alwaj's court, your case will be decided purely on merit with no extraneous influence." But judicial integrity can also be dangerous, as I experienced in my judicial career several times. And maybe I can only quote, because of time, I can only quote one incident very quickly. When I was the vacation judge, this is way back in 1995, November of 1995. I was the only vacation judge because the court was on recess, and I was sitting in Nairobi. And a case was brought to me before me that morning, and the case was from Mombasa. And every court, during court recess, there's one judge who handles all the matters. So I queried, and I was given reasons that were not very convincing to me, that we have a different a suspect. The suspect we have is a drug baron and etc. and etc. But when I read the file and I saw what is alleged that he did, I granted an ex parte order. And those were just, the lawyers who appeared before me can always tell you how very few times, if at all, I ever granted ex parte orders, because I believe that inherent in an ex parte order is an element of injustice. So I always preferred that parties must come and I hear them. But this was a matter where I had to grant an ex parte order, because this was a family that was chased out of their house. I think it must have been about five or six. They were having dinner and they were father, mother, 2 children out. House was locked. Everything was, vehicles removed from the compound, gate locked. And they went to the police station and the police traveled with them to Nairobi. So I said, okay. I granted an ex parte order and I said tomorrow morning, I gave them up to 11:30 or 10:30, I want to see the suspect. Now, the following morning, I'm sorry, but I'll be brief. The following morning, before I started the court sessions at 9, a very honorable and distinguished member of parliament, whom I knew fairly well, it was a lady, came to me. And I told my court clerk, I will not see anybody because I'm about to start work right now. And the court clerk said, so eventually, anyway, I agreed to see her because there were too many petitions. I told my court clerk, you come in with her, not alone. And when she requested that the court clerk be out, I said, listen, I'm sitting here as a judge, and there's no way that you are going to see me just before I start my sessions, and you don't want anybody else. I must have a witness. So she said, Judge, yesterday you had a case. I said I had many cases because I'm the only vacation judge on duty. But one particular case that you had, I have come to tell you that the suspect is in hospital. So I was surprised. I said, as far as I'm concerned, and I know you are a member of parliament, I didn't know you are a lawyer also, because those members of parliament who are lawyers, I know them. And she said, no, I'm not a lawyer, but I'm speaking on behalf of that suspect. So I got up, I opened the door very wide, and I told everybody connected. I read the case and the name of the accused, Ibrahim Akasha. I said, everybody that is here for this case, can you all come in? So when they all came into my chambers, I said, I believe most of you know this honorable member of parliament. I'm requesting her to repeat what she told me when you were all outside. Of course, she was not able to repeat it. She was not able to repeat it. And then I told the advocates, the lawyers, that I granted ex parte orders, and I want to see the suspect. Where is he? So 10 lawyers had come to represent him. And the suspect, the complainants, they only had one lawyer. He was very new in practice. I think this must have been one of his first cases. And the other side had 10 lawyers. So I said, you 10 lawyers, can you show me where is the suspect? So it went on, and they apologized. And I said, listen, the ex parte orders are in force. And if the suspect is not here, we are going to the hospital straight away. And the lawyers pleaded and said, Judge, if you just give us a few hours, we are going to sort out everything. We will open the house, we will return everything, blah, blah. So I said, okay, it's not possible to do it today. This is Nairobi and you're in Mombasa. You'll do it and report to me tomorrow at 11. So by the end of it, everything was done. And my vacation duty ended, and I left the next judge to pick up the matter and proceed with it. But they opened the house, they opened everything. So that was it. I forgot about it. About 3 months, exactly 3 months after that, one day I just walked out to the courtroom because the courtroom is very close to the city. And I just walked out. I thought I would walk out for just about 2 or maybe 10, 15 minutes. It was lunchtime. And when I was just about to get into a shop that was owned by friends that I knew, somebody called me and said, excuse me, Judge. So when I looked, I didn't know him. He said, listen, my name is Ibrahim Akasha. I have to talk to you. You are the first judge ever in this country who has made orders against me. So I was shocked, and I think I screamed. So he said, no, you don't need to scream. Today I'm not armed. Blah, blah. So anyway, eventually the commissioner of police was called. Everybody, it was a big thing. And that's what I mean when I say it, integrity. can also be very dangerous. And that is the only one example that I want to quote. I will not quote any others. So as I finish, I will say that having served as a judge both at national level in Kenya for 35 years and international level at the International Criminal Court for 9 years, I believe that it is much easier for a judge to observe the Bangalore principles of judicial conduct while serving at international level. I say this for two reasons. First is the serious nature of the offenses that judges handle at international level. I believe even at domestic level, but if it is at The Hague, for example, where I was, the ICC, the offenses included genocide, war crimes, crimes against humanity, and the crime of aggression. Now, the second reason I say this is because usually a judge serving at an international setting is in unfamiliar surrounding with people he or she has not met before and has no association with, I suppose. For example, at the ICC at The Hague, there are 18 judges from different regions of the world. So most judges are meeting for the first time. And this is, as opposed to national jurisdiction where a judge knows people. And also you have, people, you are a Kenyan, I know Kenyans, you have relatives and friends who might be tempted to influence a judge. They are advised not to, but they might be. So finally, is to say that for the past 1.5 years, I have been part of the Judicial Reform Committee under the revitalized agreement on the resolution of the conflict in the Republic of South Sudan. This is a country that, as most of you would know, has had conflicts for over 21 years, before independence in 2011, and even after independence in 2013, in 2016, they had conflicts now amongst themselves. So what is the state of judiciary in such a country? And indeed, the impact of public opinion on judicial integrity and democratic development. I'm happy to say that the Judicial Reform Committee we have finalized our work. We were a committee of 12. Judge James Ogola from Uganda, I believe, Professor, you must know Judge James Ogola. And I, myself, we are from the region, and 10 lawyers from 10 political parties in South Sudan. So we were a committee of 12. We have finalized our work. I have my report right here. Just the only unfortunate thing is that we have not yet presented the report. The report has not, we are supposed to have it for validation workshop and then present it to the government of South Sudan. And this therefore makes it very difficult for me to tell you what it is that we have been doing. But we have subcommittees on judicial structure, alternative dispute resolution, Judicial Service Commission, appointment of judicial officers, promotion, discipline. All those areas we have touched on, Constitutional Court. We have findings and recommendations for the people of South Sudan. We traveled far and wide in South Sudan. We've been going maybe we don't live there as such, but we go for 2 weeks, 3 weeks, 1 month. So we engage the people of South Sudan very extensively on widespread consultations. So this was a this was massive and difficult exercise, but it is done now. However, I'm not able to share it for the reasons that I have said. Maybe one day I will. And because it has to be validated by the people of South Sudan and handed over to the government of South Sudan. Thank you for your attention, ladies and gentlemen. That will be all from me. Thank you.
Thank you so much, my lady. I appreciate it. So quickly, we'll go on to the next presenter, Justice Amagata.
Yes, good afternoon.
Good afternoon, sir. Thank you, sir.
I'm speaking from Ghana, and thank you for inviting me to be part of this webinar. I stand on the existing protocols which the speakers ahead of me had set in place. And I want to say that in Ghana, public opinion is very critical in the sense that our constitution guarantees freedom of expression, guarantees media freedom, and the media are free to publish things within the confines of the law. Public opinion is the collective expression of individuals within a society regarding certain matters that have come out in the public domain, which they want to express their views, they want to be heard. And whenever in a society you have that diversity of perspectives and viewpoints, it enhances the development of the society. Nobody is shut down because we are all citizens in the country and we are all to be treated equally. In a democratic system, as we have in Ghana, there is definitely a relationship between the judiciary, or the courts for that matter, and the public. And that relationship is, in my view, is very crucial. One key aspect of that relationship is that there must be public confidence in the judiciary. If there is no public confidence in the judiciary, then you better close down the courts and the judiciary. It will lead to anarchy and chaos. And what will happen is that it will be like an animal's kingdom where might is right. When you have a problem, you don't go to court, you deal with it in a way and manner in which you feel you have to deal with it. But that is not what we are called upon to do. We are called upon to respect the law and act within the confines of the law. And therefore, there is a body, which is an arm of state called the judiciary, and they are charged with the responsibility of doing adjudicating disputes between people. Article 125 of the Ghana Constitution, for instance, provides that justice emanates from the people, and that justice shall be administered in the name of the Republic by the judiciary, which the Constitution says shall be independent and subject to no other person or institution, but only subject to the Constitution. So the Constitution itself recognizes that the judiciary's work is being done on behalf of the people, and therefore the people must be part of it. An example of people's participation in administration of justice is within the jury system. And we have some of the courts, the tribunals, where you have lay people who are represented on a panel, like we have the juvenile courts, that you have lay people from the social welfare who are represented on the panel. And we, as I've mentioned, the jury system, where you have lay people who sit and listen to the evidence and participate in it. Apart from it, the courts are open for anybody at all to enter the court and listen to proceedings. So unfortunately, having regard to the population that we have, everybody cannot enter the court and the space is limited. Over the years, we have had an importation from our British colonial masters that cameras cannot be taken to court in order to show court proceedings. I have not investigated the history of that particular thing, but the public want to know, and the public want to be heard on what is ongoing. The public want to be heard on how the courts are managing their work, how they are doing their job, and all those other things. They want to be part of it. So the debate that has been ongoing is why would you deny the public the opportunity to listen to proceedings in court and form their own opinion? In England right now, the Supreme Court has a website, and for me sitting in Ghana, I can click on a website in which I will listen to proceedings of the United Kingdom Supreme Court right from beginning to end on the daily basis. And these are inheritance that we got from the colonial matters. They have gone out of it, and we are still holding on to it. So the public want to be part of it. They want to involve themselves in administration of justice, because everybody cannot be in court and listen to justice delivery. What is happening is that it is the media, the court reporters, who are allowed entrance into the courtroom. They listen to proceedings, they report, and what they report is what people debate. We have had instances in which many of the reportage from the media have been influenced by other forces such as some of the media personnel belong to political groupings. And when they go to court and they listen to proceeding, they are able to tweak their reportage in order to suit whichever political persuasion or whichever group they identify with. And these are some of the challenges that we have with public opinion being involved in the administration of justice. Public opinion is good, and it is good for the citizens or popular participation in administration of justice, but it has challenges, but the challenges are not insurmountable. The challenges ought to be kept, they ought to be identified, and they ought to be dealt with. So it is very interesting that in a country like Ghana, we've had occasions where the courts themselves will have to deal with issues against the justices or against the courts. The courts will have to hold on to these matters in order for the court to stand firm and administer justice according to the way and manner justice is supposed to be administered in a country. I have my own experience when I was in private practice before I was elevated from private practice straight to the Supreme Court. I've had clients as a lawyer, and clients feel very happy when they are able to penetrate the offices or the homes or judges. When a client or somebody is able to ask for the home of a judge and is able to go to the home of the judge to discuss issues involving his case or influence the judge, for the clients, they think that they have achieved the ultimate, because they see the judiciary they put the judiciary on a very high pedestal, as we all do. And therefore, if you, considering yourself as a nobody, you are able to penetrate and get to the judge, then you must consider yourself lucky. So I remember during my 25 years lecturing at the Ghana Law School as a lecturer, I kept on warning students and lawyers and potential judges that I trained to be very careful, because when clients go to see judges, whatever they do, whatever they discuss with the judges, when they come back, they come and tell their lawyers. And therefore, we are talking about integrity. Integrity is very key for the work of a judge. At the same time, members of the public will want to do the wrong thing. And when they do the wrong thing, they do not expect that judges will succumb to the wrong attempts of machinations which the members of the public or the parties have decided to involve themselves in. But when you succumb, they feel proud and they go about boasting about it and they share it. So when you are a judge and you don't administer justice according to your judicial oath, and you either succumb to corrupt practices or you allow yourself to be influenced by the politicians and others, members of the public will get to know, because those who came to see you and to influence you will go out and they will tell their colleagues that where you have any problem, you can go to the home of this judge, or you can go to the office of this judge, and he will sort it for you privately over there, and you can leave an envelope on the table. That is not good for us. We ought to improve upon what we have been doing and what we have done over the years. Public opinion is good for the administration of justice, but it must be done within the confines of the law. We have had occasions in which, in the course of expressing public opinion on the work of the Supreme Court, we were compelled.
My Lord, sir, I beg your pardon, sir. I totally don't want to be rude. I know that the Chief Justice took quite a lot of time, and we have 2 speakers more, and it's almost at the end of the program, and one of the speakers really has to leave. The next speaker has to leave. So, and we have questions and answers coming up, which is...
Oh, all right. Sorry. I thought I had 15 minutes. I was told I had 15 minutes.
I sent you a message, sir, but because I didn't have your phone, it was difficult getting in touch with you like the others. Usually,
I send
emails.
I didn't get it.
I'm sorry.
I didn't get it. So let me conclude.
The chat bowl.
So
thank you.
Yes, let me conclude by saying that public opinion is good, but it must be exercised within the confines of the law. Thank you.
Thank you so much, sir. Leonard is saying, I beg your pardon, I'm sorry. Yes. The next speaker, please. Senior Advocate Candy Johnson. Thank you, sir.
Okay, thank you very much. I'm sorry about that. I was saying thank you very much. I got the message about the 10 minutes. I'll try to do this in 5.
Thank you,
I
sir.
thank the Chief Justice for his compendious speech. It was threw a lot of light on the topic. And the Lady Justice also, her personal recollections regarding her own safety in the course of her work. These are all important things. My perspective, of course, not being a judge, is beyond the defense, if you like. It seems to me that very often when judges talk about their work, they get defensive and they tend to labor us with the challenges that they face, and I appreciate that. You know, my father was a judge, my brother was a judge. I come from a family of judges, but the office of judge is a public burden. It's a public responsibility, and it's a hugely important task that people undertake to carry, and we thank them for it. But we have to analyze their position, and in the context of the topic that you've posed to us, we need to understand how this function should be carried out. Now, some people think judges are spirits. When I was young, you know, people used to take off their hat when they went past the judge's house, and people used to take off their shoes, in fact, before they passed the frontage of certain compounds. So I understand that people see them, and you know, the whole drama of the English judicial attire in tropical Africa is something that tends to look very much like maybe our traditional masquerades. And so you can understand why the people would be alarmed. But beyond the fancy dress, beyond the ceremony of the English judge, we need to know that the court is a political institution. It is the function of, we can read up sections of the Constitution and quote sections of the Constitution, but we have to understand, when we talk about integrity of a thing, we have to know what its purpose is. We can't understand its purpose unless we know why it was founded, and we need to know its history. So we know something of the history of our judiciaries in Africa. These were created for the purpose of defending a certain colonial status quo. They were created for the purpose of ensuring order, economic progress, and democratic or on governmental stability. This is the primary function of judges. You know, I repeat again, judges aren't spirits. They're human beings carrying out public office, and the public office is as a pillar of government. Judges, some people say, oh, judges should have decided this matter in this favor. Judges are not there to upturn the social or the political or the economic order. They're there to defend it. The rule of law presumes that that exercise is valid because it gives equal access to people, apparently, and invariably there is an impartial outcome and a similar outcome across a wide range of cases. And so as Judge Amagecha pointed out a few minutes ago, public confidence in the institution of judging is fundamental to its effectiveness. You can't depend on sympathy or on victimhood or on the Constitution or on long-standing tradition to defend the authority of a judge. The authority of a judge comes from two things: from his reputation for impartiality and fairness, and from his personal dignity or her personal dignity. And, you know, there are good judges and there are bad judges everywhere in the world. I don't accept that bad judges can hide under the toga of being a judge and evade or deflect criticism. In a democratic society and in the democratic context in which these judges operate, again, I repeat, as pillars of government and a functional leg of a governing coalition or a governing contraption, the people who are governed are exactly the constituency who need to be convinced of the validity of the decisions and the actions that judges take. So it's very important that they have access to the architecture of judging. It's very important that they have access to criticism, and judges should be willing to take criticism because that criticism is what keeps them honest and keeps them straight. I think that the Chief Justice in his speech quoted, I think it was Lord Denning, who spoke about, I think one of the cases that he referred to, even if he didn't quote the case, is the Attorney General and Times newspapers in 1982 or so, where the House of Lords in England said, look, you know, we don't fear criticism. We perform a public function, but you can't interfere in the administration of justice. You need to separate things and know what can and can't be done. And Lord Denning's actual remark, which I think the Chief Justice quoted, was about judges not being able to defend themselves. This is true. This does not impede the right of the public to inquire into what they do, to criticize what they do, and to demand accountability in the public space for what judges do. The fact that judges cannot speak for themselves means, as Lord Denning himself said, that they must depend on their conduct to be its own vindication. Protecting the reputation and the integrity of judges is a task of judges. There's no escape from it. So I think that it's important, if you recognize the purpose for which that institution is established, that it has a critical impact on the stability of our democratic process in our system, then it has to be tested, it has to be exposed, it has to be made accountable. As someone said, sunshine is the best disinfectant. So the things that we despise, that we abhor in the process of judging are things that we're entitled to inquire into and the things for which an answer must be given. There is no difficulty or dispute about that. And the final point I should make, if I may summarize, is that the test of the quality of our judging and the test of all these questions we pose in a hypothetical manner is to try and extract the impact of judging and this institution of government on the sustenance and on the preservation of our democratic practices, our culture and experience. We can, in Nigeria, for example, there are a lot of cases where which have tested that confidence, but it's something that the judges also need to realize that they're fundamental to this democratic practice and the democratic culture, and they're a pillar of the government, and that they must conduct themselves in a way that will uphold the value of their work. I hope that's taken no more than 5 minutes.
Thank you so much, sir. We appreciate it. Thank you. Next speaker, right on, please. Ms. Karim. Can we please send our questions and comments as soon as we can so that we would... Ms. Janet Karim. All right, we'll take questions. Bayo, please, can we take any questions? Do we have any questions so we can move on?
Okay. Why I haven't seen any questions, but I've noticed that Honorable Justice Taiwo has a brief comment, so I'll give him like 2 minutes.
Okay.
Honorable Justice Taiwo, 2 minutes, please.
All right. Thank you very much. I'm so glad to be here. And I thank all the presenters. I want to say that the protection of judges and judging is not entirely that of judges, because the judges don't have a say after their judgment is delivered. But then we have some lawyers and some stakeholders who, for personal reasons, think that the judge ought to have decided one way or the other. And then some of them go to the press and say all manners of things, and the judge cannot say anything. I'll give you a very brief example. And we have to tell the attorneys general, whether at the state, federal, of any, especially in Africa, that they have a right and a duty to protect the integrity of the judiciary. They ought to be the one that will go out and explain in a pedestrian manner the decision of judges. What will you say of a judge makes an order, and then the person that is vilifying the judge is the Attorney General? How does that sound to anybody? Public opinion is cultural in Africa. And it depends on those that are educated and enlightened, and lawyers especially, to try and defend. When a court says, a provision of the law says, you can detain somebody for 90 days. And the judge says, okay, 45 days. And after the 45 days, nothing is done from the prosecution. And then the judge says, go home. When they are ready, come back. And the next,
my lord, can you
find, yes, the next you find is the Attorney General vilifying the person.
Can you hold that thought for a moment? Speaker Janet Karim is ready. Sorry, can you hold that thought for a while?
Oh, okay.
Last speaker is ready, Janet Karim. We'll call you right back when she's done. Thank you.
Thank you.
Okay. I yield.
Hello. Hello. Can you hear me now? Hello? Okay.
Yes, please go ahead.
Oh, you can hear me.
Please go ahead. Thank you.
Thank you. Distinguished speakers, guests, and my sister Ari, all protocols observed, I am honored to speak at this dialogue on the impact of public opinion on judicial integrity and democratic development. My presentation is entitled Malawi Legal System Scores Great Electoral Win for Malawians, Orders Fresh Presidential Elections. I opted to weigh in with commentary on the actions of the Malawi judicial system in relation to the Malawi 2019 presidential elections and the 2020 fresh presidential elections. The Malawi Constitutional Court, excuse me, the Malawi Constitutional Court, which was their decision of in 2021 in the 2019 electoral case, makes me a very proud Malawian with unquestionable confidence in our judicial system and its integrity. This integrity character was propelled by Malawi public opinion. In 2019 presidential elections, the public opinion was that their votes had been stolen to favor incumbent President Arthur Peter Mutharika. The media was on hand reporting the public opinion that was being expressed and these sentiments. The judiciary gave its verdict and administered justice. Now, background on this. In May 2019, the Malawi Electoral Commission, chaired by former Justice Jane Ansah, declared incumbent President Arthur Peter Mutharika as the winner of the presidential election. This was despite there being massive anomalies. The MEC, the Malawi Electoral Commission, announced that the results as follows. Mutharika had 38% of the votes, and the opposition party leaders, Lazarus Chakwera, got 35%, while Saulos Chilima got 20% in the final tally. One of the anomalies was the presence of so many tally sheets that had its result sheets with sections blotted out or altered with correction fluid. And this could be seen all over the world. People could see these tally sheets. As Team Mutharika prepared for victory celebrations, Malawians poured out onto the streets countrywide. As a journalist so many miles away from Malawi, my heart bled when I saw a picture of a woman with her baby on her back and a plastic bag, possibly with food and diaper change for the baby. It was these pictures of peaceful demonstrations calling for Mutharika to give us back our votes that led to the opposition candidates, Chilima and Chakwera, to sue and seek the court for an investigation and determination of what had happened during the elections. The Chief Justice, the then Chief Justice is now retired, Andrew Nyirenda, and members of the Supreme Court established a special constitutional court called the Constitutional Court, and it was headed by Potani. The first to go to court was Chilima, but he was soon joined by Chakwera. As the Court, which I like to call them, the plaintiffs delivered their points in the 2019 disputed election case. The panel heard the arguments, considered the massive evidence of possible voter fraud. Men, women, children, able and disabled, young and old, continued to hit the streets even as the case was being decided on, or the justices were hearing the case, and public chanting, "Give us back our votes, give us back our vote." The full panel of the Constitutional Court was, Justice Potani was headed by Justice Potani, Justice Ivy Kamanga, Justice Tinguswayo Madisi, Justice Michael Tembo, and Justice Professor Letson Kapindu. Every day, the justices arrived to court under armed escort and wearing bulletproof vests and delivered their 500-page ruling, which upheld the Constitution and defended citizens' demonstrating rights in the most difficult circumstances. The Concord ruling nullified the MEC core of the 2019 elections. They furthermore requested the Parliament to pass into law and set the date for a fresh elections. For the first time in Malawian history, the citizens were in a place where a president with a defense force at his command and refusal to call for fresh presidential elections. This was the second time that the president could decide to say, "I'm calling on the army and to stop this nonsense," and they could have stopped the Constitutional Court. The other time that the judicial system could have fought with the president was in 1994, when the vice president lost the elections. He too could have said, "Nope, I'm calling in my defense force," but they didn't do that, and it didn't happen in 1994, and it also didn't happen in 2020. They didn't annul the decision of the court. They assented to it and allowed the public opinion to weigh in and pave the way for fresh elections. In 2020, incumbent President Mutharika could have refused the fresh call, but as I said, he didn't. The Parliament did introduce a bill, then President Mutharika signed it. Meanwhile, people continued to flood the streets, calling for the return of their votes. On June 23, 2020, fresh presidential elections in Malawi overwhelmingly elected Lazarus Chakwera for president, and his vice president was Saulos Chilima. And they formed a coalition government called the Council Government, and they got more than the 50+1, which the parliament had said that the president, the winner of the elections, must get 50% +1. of the votes, and they got 3.5, which was more than that, 3.5 million votes. On its part, the Malawi media, print, broadcast, television, and even social media rose up to the challenge and kept the readership in and outside Malawi to know about the nuances of the case and the situation that was there in Malawi. Keeping the readers' viewership informed was fueled by the mass participation of the citizens. And it was just, it was, the pictures are they're heartwarming, because this is the time when Malawians spoke, and they spoke persistently over months to say, we want our votes back, and the judicial system, ruled that the fresh elections must be done within 150 days. Because they could have just said it must be done, and Mutharika would have sat on it maybe for a year or 2 years before he allowed it for recording of the fresh elections. But it was given a time limit, 150 days. There was a bribery attempt, of course, when the justices were deliberating the case or hearing the case, and persons were nabbed and sent to jail and then released, of course, due to COVID. In 2020, there was COVID, but the justices refused to be bribed, and they delivered the verdict in favor of people, and more pride for the judicial system in Malawi. What is the judicial system in Malawi? The judicial system in Malawi is a hybrid of different legal systems, the British, Roman, as well as US law. So it is, a great thing. And the decision made the court a pro-Malawi people court. And it's just a wonderful thing to look at. Of course, there's still people that are trying to corrupt the justices. It's a terrible situation to be in. But in 2020, I think the Malawi judicial system was held to its mettle. It had to show that it had integrity. The call for incumbent President Mutharika was wrong in view of all the things that were being shown, the correction fluid tally sheet, or unsigned tallies, but still being tallied within the whole count. So this is what I wanted to say, that the courts, they in Malawi, always well. Thank you very much, Madam, distinguished ladies and gentlemen.
Thank you so much, ma'am. Thank you. I appreciate it. Thank you so much. We are going to just take a quick questions. Bayo would have 1 or 2 questions for us. And then we would round up. So quickly, just a cap up that the Chief Justice had given us a detailed, well-researched paper, and we appreciate his definitions, jurisprudential approach to defining public opinion, judicial integrity, which was a wonderful base for us to continue our discussions. His specific dimension on human rights and how that impacts public opinion and the issues of the international scene, that was very, very apt. That is an entirely different a topic for an entirely whole day seminar, which was very, very impactful for me, especially on the research concerning Uganda and issues of the anti-LGBTQ law and the sanction against them, or ban issues of the EU laws. And then we heard also from our next speaker, who had given us a fantastic, more like a follow-up from the Chief Justice's presentation. And the fact that Milady Joyce Aloj gave us a personal opinion of what she considers, a very important aspect of judicial integrity. And I picked up that aspect of the danger of judicial integrity, which is very key. And even though we know that Leonard SAN Candy Johnson did say a little about how judges may be saying, you know, I don't know if I got him right about their so much trouble that a lot of judges go through and all of that aspect, giving too much or so much into the job and all of that. There's an aspect of being a judge that is very, very dangerous, as in the quote of Nikki Toby that I'd quoted earlier. And only the one who wears the shoes will know how it pinches. So her personal experience, even though she gave us just one of several that she had, was very, very instrumental to the talk on issues of judicial integrity. She stood up for herself in court and made sure that the parties understood the importance of being transparent, as one of our speakers did say, and that kind of got her into trouble years later, where if he had a gun, he probably would have shot, because he said to her, no, I'm not harmed. At this time, I'm with you, so you're lucky. So this is a part of the stuff that judges go through, that a lot of judges are not the platform or the opportunity to say out. And then Honorable Justice Amegacha had talked about public opinion. And of course, Judge allowed to mention the issue of the press, which Judge Amegache gave a very interesting aspect as well, and talked about the public confidence and the importance of the media and what they report, and how media reporting is very key and crucial to the public opinion. And the confidence of the people in the judiciary is key and critical. Otherwise, if the public does not have confidence in the system, there would be anarchy and chaos. And of course, SAN, Candy Johnson, and Leonard Advocate of Nigeria supported that, and did talk about that judges need to speak. If judges cannot speak up for themselves, reiterating the quotation of Lord Denning, that they needed their characters and their integrity to speak for them. And he felt that public confidence in judges is very fundamental and effective to democratic development. It's key with what he said that I got was the authority of judicial integrity is based on the reputation of impartiality and fairness of the judge, and the judge's personal dignity. And a lot of times we see that judges have issues with that aspect, because people say things that they don't know about the judge, or what the press gives them, little information. So most judges don't even have the opportunity to defend themselves as such. And he did say that the test of quality of the judging is to extract the impact of judging on sustaining democracy, which is fundamental and key. And our last speaker, we had heard from her, which, I mean, from all the dimensions we've heard from, her presentation was unique in the sense that she was happy with the judiciary of Malawi. She said that the integrity of Malawi was commendable, as the public opinion was expressed in the elections of the Malawi election of 2019. And she talks about how that election has brought public confidence into the system. So we thank you all for your patience so far. We're going to take a few questions. And I hope that Bayo is ready for the questions.
Yeah, we'll be ready for a while. Justice Tayo, I will 1 minute, finish your thoughts. And I've seen 2 more hands up, so please get ready to put on your mic to make your comments. Thank you.
Thank you. Please, if we just take less than 1
Yes,
minute.
my thought is, you can't force public confidence. You cannot. That is just sums up everything. And if you are going to force it, at what price? Will it be at the price that you sacrifice the law because people are talking? I'll rest my case.
Okay, thank you very much. I saw Professor Agomo's hands up before. Professor Agomo, are you still ready to speak? I also saw Mr. Andrew Purutz. Are you, please unmute, and then let's have your thoughts.
No, I'm fine. I'm fine.
Okay.
Professor Agomo,
Yeah,
I'm
Professor
fine. Yes,
Chioma.
thank you.
Thank you.
Yes, thank you.
Hello, Andy Puritz here. Did I hear my name taken in vain?
Thank you, Andrew. Please, you have the mic.
Oh, well, thank you very much. I've enjoyed listening to this very much. I've had the pleasure of meeting Ms. Toby in a professional capacity over the last several months. I'm a criminal defense lawyer in upstate New York, in a beautiful little city called Oneonta. And I've been doing this for a very long time, since Jimmy Carter was president. And the role of public opinion, I think, varies in inverse proportion to the seriousness of the charge. The more serious the charge may be, the more important, perhaps direct proportion is the correct phrase, the more important public opinion is. Just a few moments before we went online for this program, I was speaking with a man on the phone who had been poorly treated in a matter of business, and in his fury had sent nasty and threatening texts to the person who was giving him a hard time on Facebook. And now he finds himself charged with aggravated harassment. And in fact, he regrets having done that. Okay, small potatoes case. You know, tomorrow I have something more serious going to trial. But the point is this: public opinion really doesn't enter into a case like that. What you need is an honorable local justice who's going to hear the facts, a district attorney who's going to weigh the relative proportions of the involvement, will arrive at some kind of non-criminal disposition, hopefully with a handshake involved. Now, tomorrow, the case that I'm going into court on is a very highly publicized sex crime. Public opinion in the form of online comment, in the form of letters to the editor, those things count tremendously because you have to draw on the local community for your jury pool. And that's going to affect the way people think about it. So I've been very interested in hearing that this sort of contextualization applies in many different countries as well as in my own. And thank you, Ari, for inviting me to participate in your program.
Thank you, sir. I sent you a comment, a message in the comments. Please read it. Thank you.
I will.
Bayo, please go on.
So thank you very much. We've run out of time, Ari, so I'm just going to hand over back to you. But I would say this is that we're in the age of technology where you have WhatsApp, you have Facebook, and people talk a lot, people say things, and you can't control everything that people say. But I think we, the lawyers, have a role to play in protecting the integrity of the judiciary as much as we can, not shielding it from the evils, but speaking to it when it's not going right, but at the same time, speak to it when it's doing what it's right. We have to just maintain a balance. Thank you, Harriet, for this. Over back to you.
Thank you so much, Bayo. I appreciate it. I had asked, so the person that was supposed to give the vote of thanks did not get back to me. So I was wondering if, and I'd also asked if Attorney Pruitt, Andrew, could you please give the vote of thanks? All right. Thank you so much. That I would thank the Honorable Chief Justice in absentia, and I know that his representative is still here with us. We appreciate you all, and sorry that we're 7 minutes behind on time. We're supposed to end by 10:30. We send our words and condolence and appreciation to the Honorable Chief Justice of Uganda, who is presently supporting the President of Uganda as they have a national event going on presently at the moment. It's on the internet, where one of their respected, renowned prosecutors was murdered. So we thank the Honorable Chief Justice and Professor Kaukau for coming here and giving us a well-researched and detailed paper. I also want to thank Lady Joyce Alouch specifically for a wonderful person that she is to me, and I thank her for giving us our experiences that gave us key insight into the international courts and the Kenyan courts. I want to thank also Honorable Justice Amagacha. Thank you so much, sir. Thank you. We would definitely hear more about your research in the paper that we hope that you will be sending to us so that we can send out published versions of all the papers as soon as possible. Thank you so much, sir. And we thank you, Leonard Senior Advocate of Nigeria, Candy Johnson. Thank you so much for your input as well. And thank you, Ms. Karim. I appreciate all of you, professors and students. We have some research students here also. We have Justice of the Supreme Court of Nigeria. Thank you, milady. Justice Ogumiju, thank you so much. And some not put out your names or renamed your names, I wouldn't be able to know who you are, but thank you. I appreciate you. Thank you for coming. Those of you representing the NGI, thank you. Thank you so much. So our next Court and Society webinar series would be on August the 15th. Would be August the 15th. So please look out for our comments and postings for the next webinar series. Thank you so much and God bless you. Thank you. Thank you, Mr. Atley. Thank you, Dr. Zerbi. Thank you. Who's this person? Thank you, Ms. Paris. Thank you.
Very well done.
Thank you
Very
so
well
much.
done.
Thank
I'm
you.
going to get off now. Thank you.
Thank you
you
so much. Thank you.
Yeah.
Thank you, Dr. Jamilo. Thank you so much. Thank you, Georgina.
Professor Shodipo is also here. I see a lot of people
yes,
from Africa
you.
also here. There's Jean Kayira is also here. Is it Jean or Jean? There's quite a few people. Yeah, thank you for coming.
There's this person who has justice there. Thank you. Thank you so much. Thank you, Atim Sheila. If you're a judge, sorry.
Mr. Pabio, thank you very much.
Yeah, congratulations. Bye.
Thank you. Thank you so much. Thank you. Thank you, Pastor Ibembe Julius. Thank you. Thank you all so much. And for those of you who have we were here earlier, thank you so much. I appreciate you, and we hope that we would have a more impactful, as the moments go, as the days and the years go, would have more impactful sessions. We've had really wonderful ones in the past. Thank you so much, and God bless. Thank you to Bayo and every other person that has supported and helped with the technology. Bye-bye.